For those of you that don't know me, I'm Steve Levine with Ignite Consulting out of Texas, and we do compliance, best practices, training, and other work for mostly independent dealers, some finance companies. And I'm here to talk to you today about what I think is the most significant danger that y'all face, and that's lawsuits. Because there's only one CFPB, there's only one FTC. You have a state regulator, but they're regulating a lot of different businesses. But in every town, I don't care whether you're in a small town or a big town, you got a bunch of lawyers that are looking to make money suing car dealers, suing creditors, suing anybody on behalf of consumers because they're going after the pockets. So that's the risk that you guys face. And before I got into compliance, I spent the first 10 years of my career doing litigation, defending car dealers. Because as a young lawyer, you want to get to court, you want to learn quickly, and those car cases are the ones that get you there. So literally first decade that I was practicing, it was litigation all the time, lots of car dealer cases, every crazy fact pattern you could imagine. Back then, this is in the early 90s. Back then, there was something called the Deceptive Trade Practices Act, and every state has their own version of one. And that was the act that was used to go after car dealers. And most states have like a list of things you can and can't do. So you would have those kind of claims, you would have maybe fraud, maybe breach of contract, and that's really what you saw. And there were very few good plaintiffs' lawyers, and there were a lot of ones that really didn't know what they were doing. That's changed. The world for you guys has changed since Dodd-Frank, since the CFPB, since they started publishing all this information about what they expect you guys to do and what best practices are in the industry. So they have a list now, and every plaintiff's lawyer in the country has access to that stuff, and they read what the CFPB publishes, and they read what the state regulators publish. And they have all this material out there that they just have to click a button on the computer and they're in business. So it's become a lot harder. And there's a lot more risk for you guys. So, run-of-the-mill lawsuit. Simple lawsuit. I'm not talking about the kind of lawsuit where somebody goes to small claims court, pays a $50 filing fee, and you have your 10-minute trial. I'm talking a real lawsuit where they go to court, they get a lawyer. I don't care whether it's a repossession, breach of contract, whatever. This is really optimistic. It's going to cost you about $15,000, best case, to defend that lawsuit, if it's a real lawsuit. And that doesn't even count the attorney's fees you may have to pay the other side if you lose, and that doesn't count any verdict against you or any settlement. That's just bare bones. And that's a wake-up call to a lot of people because that's real money. And that's, you got to allow for it. You got to plan on it. And that doesn't even take into account a bigger case, a more substantial case. I mean, this is just bare bones, basic stuff. So, I want to talk about two recent cases that I think are a really good example of how dealers get sued. So in the first one, it's a class action against a dealer. And it's a really weird fact pattern, but it happens, something like it happens a lot. So, guy comes to buy a car from buy her, pay her dealer. And almost immediately, he gets really undependable, but his girlfriend's driving the car, and his girlfriend contacts the dealer, and girlfriend's making the payments. So then after about a year, boyfriend goes to jail. Girlfriend says, well, I'm still driving the car, I still want the car, but I'm not even on the contract, so you got to do something for me. You got to put me on the contract. The dealer, well, okay, so he gets out the contract and just has her put her name at the bottom, which is a problem for like 10 different reasons because it's closed-end credit and it was signed a year ago and a bunch of reasons. There were problems with the contract. There were some fees that maybe shouldn't have been charged, that there was a usury question. Well, all the dealer did was have her sign the retail installment contract. None of the extra documents, none of the document package, which contained an arbitration clause. So the dealer's protected with the arbitration clause, but in this case, the dealer is not protected because She didn't sign it. She just signed the contract. And they tried to make a class action out of it, and the defense costs are pretty darn staggering. I mean, when you're talking class actions, that slide I showed you about $15,000 to get to court goes out the window. It's a lot more than that. So there's a good example. And you all have employees trying to do the right thing, trying to help the customer, don't know any better. And stuff like that happens all the time, whether it's recontracting, whether it's side notes, whether it's all this different stuff that you all do in the day-to-day course of your business happens all the time. The second case is one that really ticks me off, to be honest, because it's a dealer in my area. And they sold the car like in February. In March, the customer got a notice that the insurance was canceled. Dealer tries to contact the customer. Customer doesn't come in. They wind up repossessing the car. Well, that happens all the time, too. Well, lo and behold, customer goes out and gets a lawyer, is able to prove that the insurance agent actually sent proof of insurance. Dealer never called. Dealer never asked any questions. But the thing that really got him in trouble was there was a $500 repossession fee that they put on the account that they couldn't justify because one of their employees did the repossession. So there was no third party, there was no truck, there was no nothing. But in their 10-day letter for the repossession, they charged $500, they recited it, and it turned out to be a really big case. $100,000 verdict just about against the dealer, plus attorney's fees, plus the plaintiff's attorney. I mean, that's a case that could put you out of business. And those pop up all the time. This stuff happens all the time. I get calls all the time about, can I add this fee? Can I add that fee? What about this? You got to be very careful on any charges that you want to put on an account because somebody's watching. How do these cases get to the lawyers? Because you look at these customers sometimes and they don't have the wherewithal. A lot of times, customers go to see bankruptcy lawyers. And bankruptcy lawyers say, okay, I want to see all your paperwork, because the bankruptcy lawyers are looking for money. They're looking for a lawsuit. And that's who's going through your paperwork, and they know their way around the contracts and what's supposed to be there and not be there. That's how a lot of these cases start. These cases are two really good examples of poor training, not understanding the transactions, not having good complaint management. So things got escalated when they should have. And by the way, I talk about complaint management a lot in this presentation. It's really reputation management. And if you don't have a good reputation management strategy, you really need to get one because it's so important. So, like I said, both of these cases involve fees being charged to the customer, not having good notes, not having good records, things like that. This stuff happens all the time. And you need to start looking at your business. If I were to get sued, what would they go after and how am I going to defend myself? How good is my note taking? How good are my employees being trained? Do they ever contemplate any of this stuff? Because that's the real world. There's a lot of plaintiffs' lawyers, and they love to sue car dealers because they perceive it as easy money. So why do dealers get sued? In my experience, and I've been doing this over 20, 25 years, the number one is if the car's not working and you're still trying to collect on the account, customers are very likely to seek either regulator help or attorney help. So the better collateral you have, the less likely it is to get sued. The worse collateral you have, you're going to have more complaints and more lawsuits. The complaint management, that's a big one. I tell all my clients, you got to give your customers a pathway. I want a sign in your place. Tell us how we're doing and give them an email address, give them a phone number. I want it on a website. You give your customers the pathway, they're going to follow the pathway. If you don't give them a pathway and you're not listening to them, then they're going to get angry. They're going to want to ventilate someplace. So they're going to go to social media. They're going to start calling the regulator. They're going to go to the Better Business Bureau. So give them the pathway. Don't say, for complaints, go here. Say, tell us how we're doing. If customers have high payments that are unrealistic, that's a recipe for disaster in this day and age because the CFPB is talking a lot about ability to repay. State regulators are focusing on ability to repay. and now plaintiffs' lawyers are focusing on it. So I know elsewhere in the conference you heard about abusive practices. Selling a car, financing a car that they don't have a realistic ability to repay, that's considered an abusive practice. So that's a big one too. Stuff like not paying off your trade-in, that's another big one. That's easy picking. Not getting them their title for months at a time, stringing them along, that's one that they go to regulators with. Just about anything that happens with collections is a potential lawsuit if it's handled the wrong way. The credit reporting, for those of you that do credit reporting is now the number one lawsuit being brought against creditors. And they're really dangerous cases. And it used to be there weren't very many lawyers that were good at bringing those cases, but now, thanks to the government, there's a lot of information out there. There's a lot of lawyers that are pretty good at it, and they know the tricks, and those are very expensive cases to defend. They're hard to get out of. So if you do credit reporting, we'll talk a little bit later about some things you could be doing to protect yourself. You've got to manage that risk. You have to have a strategy in place to minimize your lawsuits. You have to think about this stuff. Sun Tzu, you prepare for the war before it's fought. That's what we're talking about today. You've got to build your defense ahead of time. So what do you do before? What do you do to defend yourself? Number one, I would not be doing your business without errors and omissions insurance coverage. I'm not talking about general garage liability coverage. I'm talking about errors and omissions coverage that protects you from the bad acts of your people. If somebody makes a mistake, if somebody says something wrong, if paperwork is wrong, errors and omissions coverage. It's not cheap. So what you need to ask yourself is, okay, if I get in one of these nasty lawsuits and I need to get the errors and omissions coverage and pay my defense, there's going to be a deductible. Can I survive a $10,000 deductible, a $5,000 deductible, a $20,000 deductible? The cost of the insurance is directly related to how big the deductible is. Look at it as catastrophic coverage. Pick a high number that makes the coverage affordable, but get it. And if you have any questions about where to go and how to understand the policy, my contact information is at the end. Just give me a call. But this is like the number one important thing. You got to have that coverage because the insurance company will provide you a defense. You'll have to pay the deductible, but they'll provide you a defense. And these cases sometimes are hard to get out of. You may be litigating for 6 months to a year, thousands of dollars every month, unless you have the insurance company paying the attorneys. So that's number one. Number two, use arbitration clauses. I'm not going to ask for a show of hands about who does and doesn't use them. Arbitration clauses are so valuable. Don't leave home without them. We could debate the good and bad of arbitration. The best thing about arbitration clauses is they all have class action waivers. Plaintiffs' lawyers love to threaten class action and bring class action lawsuits because that's where the big money is. If you take that away from them, it takes the wind out of their sails, it's discouraging to them. You want to discourage plaintiffs' lawyers every chance you get. Use arbitration clauses. That's a big one. Do a document review at least once a year, preferably more often than that. I used to work for AutoStar, a DMS company. And for some reason, documents change over time. There's a little glitch in the system, a column moves, a plus sign gets added someplace. Stuff happens. And forms get added again, forms get taken away. I do a lot of document reviews, and I rarely do one that everything's pristine, perfect, no comments. There's always, contradictions among documents, inconsistencies. Get a regular document review. You want to make sure the paper you're writing isn't just ticking time bombs out there. Do a collections review, too. Regularly look at your collections letters, look at any texting templates you use, email templates. Look at all that stuff. I call it document creep. Very often, every time you get a new collection manager, they bring their forms with them, and one form after another form after another form, and what started out as 3 letters turns into 15 letters, and you have no comprehensive strategy, your forms are inconsistent, you're giving customers confusing information, and it all gets brought up in the lawsuits. Complaint management, again, really important. Your people need to understand the path that they should be following. What is a complaint? Where does it go? How does it get escalated? What do you do? Because if you're not responding to people, if they don't feel they're being taken seriously, they got the BBB, they got the regulators, they got, the news. I had a dealer recently call me. Customer posted something on Facebook and it went viral. And this is a small town. 40,000 views on Facebook about this irate customer. 40,000 views within a couple of days. Social media is really scary. You, as part of your complaint management, you should have a social media strategy. Policies and procedures. You all have gotten it beaten upside your head for years now about policies and procedures. But this is the other part of the conversation. Why are policies and procedures important? Because I want to be able to defend you if you get sued. If you don't have any policies and procedures, the plaintiff's going to say, they don't care, they're an evil company. They're dishonest. They don't have any controls in place. If you have policies and procedures and you train your people on them, I get to portray you as the good guy. They're a good company. They're trying to do the right thing. Policies and procedures are so important. I'm not going to tell you that you have to have 10 or 15 or this and that. Depends on the size of your business. Depends on what you do. But have some policies and procedures and train your people on them. Training is so important. Training is like my word of the year. You have to train your people. You have to give them the tools to succeed. Like in those two cases that we talked about, those two examples, it was poor training. It was the employees not knowing what to do when an oddball situation came up. You got to cover these things. You got to anticipate them ahead of time. I know there was a class on compliance management systems yesterday. I know that's something that you're probably sick of hearing about. What does it all mean? To me, it's real simple. It means having the policies, having the training, letting your people understand that there's a compliance aspect to the business, and just kind of building that mentality, ingraining it in them. If you do that, you are so far ahead of the game. My word of the year last year was transparency. Be transparent in your dealings with the public. It's too dangerous now not to be. You've got to make sure that your customers understand what's going on. Don't rely on your retail installment contract, some language on the back. If it's something you really want them to know, prepare a separate document in big letters and have them sign it. Make sure they understand. Be transparent. And finally, pick a lawyer before you get sued. When you get sued, you may have only 10 days to file an answer. You don't want to be interviewing people and trying to figure out what you got at that point in time. Find out who represents the dealers in your area. Find out what kind of cases different lawyers handle. Those credit reporting cases, the guy that does a slip and fall case shouldn't be handling your credit reporting cases. Those are two very different things. You got to find out who in your area handles what type of cases and kind of have a list ahead of time. So when you get sued and you have very little time to do something, you know where to go. Any questions so far?
I would only add also, Steve, the vendor management. Each business should speak to their vendor, no matter what vendor. I can speak on GPS, for example, and ask them what we need to do ahead of time in order to be compliant. And put that in the policies.
I'm glad you said that, because that's really important. And to be honest with you, that is something that I find dealers really struggle with. They struggle with due diligence in picking the vendors. They don't do the homework ahead of time. They don't ask the hard questions. A lot of times they don't even have strong written contracts. And then when things go wrong and they want somebody to stand behind them, the vendor's off. The vendor says, nope, it's all on you. It's your problem. You have to manage your vendors wisely. So honestly evaluate. Anytime you get a demand letter, be honest with yourself and evaluate what's going on. I've had clients over the years that were really bad at that never thought they did anything wrong, that believed anything their employees told them. And, it wasn't until months down the road, spending thousands of dollars, that they figured out, hey, I got a problem. Ask the hard questions up front. Evaluate your cases. Don't do anything with the account once you've been sued. I have seen folks try to doctor notes. I have seen people add things to a file, and it all comes out in the wash. Just do what's called a litigation hold. Hands off that account. Don't destroy anything. Don't change anything. Don't touch anything. Be brutally honest about the prospects for your case. Look at it through the eyes of an average Joe. If I'm sitting on the jury, what am I going to see? Am I going to like you or am I going to like the customer? What really happened here? Always consider how much it's going to cost to defend the case. And like I said, defense costs could go up in a hurry. It's not a matter of pride. It's a matter of economics. You may be right. The customer may be wrong. But if it's going to cost you $10,000, $20,000 to get there, is it really worth it? Never underestimate the drain of resources that you're going to experience in litigation. By that I mean it's going to be an enormous distraction. You want to ruin your month. You have your salespeople in depositions for a couple of days. They're not able to sell cars because they're in depositions. Or plaintiffs' lawyers are really good at this. They want to take the depositions of all your collectors at the end of the month and mess with your numbers. I've seen that a lot. It's a tremendous distraction. Know that. Litigation is not fun. Tell your lawyer everything up front. Be honest. I'm not going to say that I've been lied to, but I have had things omitted that I wish I could have known early because it would have changed the whole dynamics of the case. Tell your lawyer everything. Ask your lawyer the right questions. And how much is it going to cost isn't a right question, because I can't control how much the lawsuit's going to cost, because there's a guy on the other side pressing the button and doing discovery and asking for documents and taking depositions. I can't control that. The right questions to ask are, do you handle these kind of cases? What's your experience? Do you really go to court, or do you try cases, or do you settle everything? I have seen a lot of companies over the years spend a good deal of money only to find out that their lawyers don't try cases and they're caving at the last minute and want you to settle. So you got to ask those hard questions up front. Don't ever think we're never going to settle. I have heard we're never going to settle so many times in my career, and I could usually pick, are they going to change their mind in 2 months, 3 months, 4 months? Because once you start getting a couple of months worth of legal bills, you change your attitude real quick. Likewise, don't ever think they can't afford to sue. They don't have to afford to sue. There are so many plaintiffs' lawyers out there that'll do it on contingency. So don't think like that. Again, the tremendous distraction litigation causes, it'll wear you down. It'll wear your people down. A lot of car dealers think, well, if I'm not going to court today or this month, that's a good thing, so I'm just going to ride that docket. I'm going to delay. I'm going to keep on putting it off. That doubles your costs, triples your costs. Get the bad news out of the way quickly if it's going to be bad news. Don't ride the docket, because all you're doing is your lawyer's doing the work, and then they put it in a box for 6 months, then they get it out again and bill you again. And really, it doubles and triples your costs. Try to settle early. Be honest about what's going on and try to settle early, because you have an opportunity to settle something early sometimes that you never get again. Once the plaintiff's lawyer starts doing work and starts digging and starts seeing things, they might not be willing to settle. So you got to have that honest conversation early and see where you are and try to do a settlement quickly. Don't ever think fairness matters. There is nothing fair about litigation. The bad news is that just about everybody on the jury is going to be in the consumer's favor. Why? Because they're all consumers. Everybody buys cars, everybody buys TVs, everybody's a consumer. Very few people on juries are entrepreneurs like you guys. So right off the bat, there's an unfairness, and there's an injustice, and you guys are behind the 8 ball. That's just the reality. I'm not trying to scare you. I'm just telling you like it is. Again, don't wait too long to make a good offer. If you got to make an offer, make it quickly and cut those fees out at the beginning. So, I had a weird experience a couple of years ago. In Texas, I'm a member of the state bar, and then I'm a member of something called the consumer law section. And in the consumer law section, they have like a managing committee that's made up of 20 lawyers. And 18 of them are consumer lawyers, and then, like, just to try to be fair, they invite 2 people from the industry, and I got invited for a couple of years. Man, what a circus. I'm sitting in the room with all these plaintiffs' lawyers, and they're all zealots, and they all think, quite honestly, that the credit industry is evil and financing is evil. And they really believe that. And I'm listening to them talk, and I'm listening to the way they approach things. And it was an eye-opening experience to learn that playbook, to learn how they see the world. They are zealots. They honestly believe that they're the guardians of justice, and you guys are the bad guys, and they're protecting their poor innocent clients from you. I'm not kidding. That makes it really hard to do business with them because they always think there's something hidden. They always think there's a trick. So you really have to get the right lawyer on your side that knows how to work with them, that knows how to get things done. They either want a big case, i.e. a class action, or something really sexy, like the lady that locked herself in the car when it was repossessed, and she wound up being surrounded by Dobermans for the weekend, in the hot sun. True case from like 20-something years ago in El Paso, Texas. Big dollar case, a couple $100,000 on that one. Or they want the quick and easy settlement where they get, say, $5,000 for maybe doing $500 worth of work. Those are the two things they're after, one or the other. So if you're honest with what happened here, what's going on with the case, you can make a decision. Are we right? Are we wrong? Let's not give them the ability to get that big settlement out of us or run up those attorney's fees. Let's take care of it now if we can. Now, I talk about discouraging plaintiffs' lawyers. I'm such a big believer in this. You got to discourage the plaintiffs' lawyers. By that I mean you have to make them think, I'm going to have to work, and the outcome isn't guaranteed. Because there's plenty of good cases. They don't have to take a questionable case. There's plenty of good cases out there. So you got to show them that this isn't a sure thing. This is going to be work. And at the end of the day, no guarantees. So I tell my clients, I want to put you in a position to where you're going to wear the white hat. You're going to be the good guy. We're going to be able to demonstrate that you take compliance seriously. You have policies, you have procedures, you have controls in place. You teach your people, you train your people. One of the best things that you could do, I had a client that used to do this. Anytime he would come to this show or any show, the first day he got back to the office, everybody knew he's bringing in lunch, and we're all going to sit there and we're going to go through everything he learned at the conference. And then it got documented and it got put in everybody's files. That's informal training, but it is so effective. You do enough stuff like that, and I'm able to portray you as a good guy. I'm able to portray you as somebody that cares. You have that culture of compliance. It's talked about. There's meetings about it. All that matters. You got to take the wind out of their sails. You got to discourage the plaintiffs' lawyers. If you do that, they'll move on to the next one. If you don't do that, they're going to try to paint you as that evil corporation that does such bad things. So, this is a checklist I've come up with over the years. If anybody wants that, I could email it to you. It's 15 things that I think you need to pay attention to. If you do these 15 things, you're going to be in a much better position. You're going to be far on your way to discouraging the plaintiffs' lawyers. So, 15 things. What you do with this is you meet with the people that run your company, all your managers, and you have an honest conversation. Which ones do we do? Which ones don't we do? Which ones do we maybe not do so well? And then from there, you make a list. A lot of times, people will do this and go through the exercise, and then they'll call me and say, okay, here's how we scored. Let's go over it, and how do we get better? So that's what I want you all to do. I want you to grab this checklist. It's on our website, ignitecp.com, or I'll be glad to email it to you. It's just a really good exercise to do. So let me talk about these in the time we have remaining. I'm just going to run through them and talk about them. Appoint a qualified compliance officer. That's really hard to do in a small car lot where you don't necessarily have compliance expertise. But appoint somebody that's going to be responsible for compliance. And if that means that somebody is the one that reads articles and goes to shows and gets some training, great. You got somebody doing it and you're documenting it. You need to have a qualified compliance person. They don't have to know everything. They don't have to have been to law school. But I work with so many compliance people that all tell me the same story. They gave me this hat. I don't know what I'm doing. They won't let me go to training. In Texas, we call that you got the badge but not the gun. You got to give them the gun. You got to give them power. You got to tell everybody else, all the other managers that listen to this guy, compliance matters. Policies and procedures, again, you don't have to have the kitchen sink. But if I was in your business, falling out of bed in the morning, I'd have collections policy, and I'd have information security policy, and I'd have things like red flags policy, and 5 or 6 basic policies. And again, they don't have to be 20, 30-page documents. You want them to be understandable. You want people to be able to execute. But I'd have some policies that if I ever have to show I'm trying to do things the right way, I can. Progressive discipline. And people always look at me, progressive discipline, this is an HR class. Progressive discipline is so important when I'm trying to defend you. If you don't use progressive discipline, it's going to be used against you. They're going to say you don't care. If you use progressive discipline, again, I'm going to be able to paint a better picture because I could show they're trying to do things the right way. If their employee makes a mistake, they reprimand them. Maybe it's a verbal warning. Maybe it's a written warning. If you have to fire somebody, you fire somebody. But if you could show that over time, you use progressive discipline and you have a history of doing things the right way, you're in a much better defense position at that point. Plus, one of the biggest dangers you have, unfortunately, is your own employees. There is so much litigation right now, employer and employee litigation, employment law. Your employees have to know what the expectation is, and progressive discipline is the way to teach them that. So make sure you're using progressive discipline. If y'all have any questions about that, just grab me afterwards. We kind of go through it, but it's really important for your defense. Vendor management. It is one of the most important things you could do. You don't have to stop the world. I hear some companies like, oh my God, if I did vendor management, that's all I do all day. I'm not saying you have to do that, but have an idea of, okay, here's everybody we pay. Do we have contracts for them? What do the contracts say? When do they run out? Do they have insurance? Do they have indemnity if I need it? Basic things. Next, complaint management system again. Do an exercise when you get back to work. Ask your employees to define what a complaint is. My bet is you're going to get all sorts of answers, and people aren't going to be on the same page. It's one of the hardest things that we do when we do complaint management with companies, just defining what a complaint is, because there's so many different ideas. So as leaders of the company, you figure out what does it mean here. Y'all don't have to have the same definition, but everybody in your company has to have the same definition in your company. Figure out what a complaint is, write them all down, figure out where you're going to write them down, who's going to capture the information, how we're going to escalate them, how we're going to resolve them, and keep track of all that stuff. It's amazing when regulators come in and do audits. You show them a complaint log, you show them the types of things that customers are complaining about, you're transparent about it, and the regulators get a really good feeling about you. If you can't do that, they're going to have a really bad feeling about you. It's okay to have complaints. It's not okay to have complaints and not do anything about them. Everybody's going to have complaints. That's okay. But you got to do something about them. If you have, 5 months in a row, you have customers complaining about something in the service department, you got to fix it. Same thing with this compliance stuff. You got to fix it. If somebody's complaining about extended service contract or gap coverage or who knows what, you got to fix it. I love payments technology. The collection world has changed since I started doing this. It used to be all about the phone and the talk off. Now it's all about texting. It's all about giving customers the options of how they want to pay you, how they want to deal with you. If they're not paying you, they know they're not paying you, and they're uncomfortable and they don't want to have those ugly conversations. Give them an out. Use technology to drive the payments. Portals on your website that accept payments, the texting platforms, email platforms. The more you could do with that, the more you take acrimony out of the customer-company relationship. And that's a good thing, because collections is like a breeding ground for a lot of the ugly lawsuits. Repossessions and judicial recovery. Okay, so one of the policies that you should have, what's our repossession policy? When are we going to repossess? Because if you don't have that, I'll bet you that the plaintiff's lawyer is going to say they discriminated against my client. There was a bunch of people in the same bucket, and they picked on my client for whatever reason, and that's discrimination. And they're going to try to cast their client in a very sympathetic light. So have a policy, and make sure you're sticking to the policy. Make sure when somebody makes a decision to repossess, they got all the facts and they document it in the file. Those collection notes will kill you if they're not accurate. So make sure they know how to document in the file. Man, advertising is one of the biggest problems right now. Probably in the last 2 years, we've gotten more cold calls on, hey, help us with our advertising because I got salespeople saying all sorts of stuff. Social media is so dangerous. I see ads all the time. Salesman goes on their own Facebook page and, hey, come buy a car from me, 500 down. Trigger term, they don't have the rest of the information. You have to have policies about that stuff. You have to tell your salespeople and really all your employees what the rules are about using social media, about what they can and can't do, about what a good ad looks like. You don't have to spend a ton of money to do it. Just do it once. Give us a good template or two for what a good ad looks like. That includes all the terms. Here's what's important to us. Do us an ad. And then distribute it to your people. If you're going to do an ad, here's what you do. You don't deviate from this. If you deviate from this, you get a written warning. You use that progressive discipline I talked about. You control your advertising risk. You're going a long way to protect yourself. Again, credit reporting is really dangerous. I talk to a lot of dealers that are under the mistaken impression that they don't have any liability for credit reporting because their vendors do it. CFPB has shot down that argument. If you want to look up the cases, it's called First Investors, and there was another one, Drive Time. Those are the two big credit reporting cases that the CFPB laid out exactly what the expectation is. Audit whoever's doing your credit reporting. We could teach you how to do a simple audit. It's not expensive. Audit them, check the math, see what's going on. I don't know that we've done an audit yet where we haven't found opportunities for improvement. And it's a lot of risk. And I don't think a week goes by where I don't read something about one of these credit reporting lawsuits. And customers are making a lot of change. They're making a lot of money on these lawsuits. That there's a lot of law firms out there, a lot of law firms that pose as credit repair organizations that are trying to trick you and deceive you and send you letter after letter, and they're just trying to trip you up. We walk into companies all the time. They got a box. Yeah, we don't know what to do with those letters. They're all the credit dispute letters. Super dangerous. It's like a landmine sitting in the corner. Find out what to do with that stuff. Ask questions. That culture of compliance. And this is where I get a little bit preachy. It's nothing magical. It's just putting it on the agenda. When you have management meetings, y'all are metric driven. You could tell me look to book. You could quote me all these numbers. You could tell me your sales numbers, in your sleep for the last year. Develop some compliance metrics. How many complaints are we resolving? Are we getting any demand letters? What's our customer satisfaction? Keep track of those numbers too. Talk to your people about it. Make it part of what you reward and incent. GPS and starter interrupt devices. Great products. I love the products. But you got to use them right. They come with great responsibility. You're getting a lot of information about your customer. You're getting your customer's habits. You're getting all sorts of information. So you have to have controls in place. You have to have a policy that tells your people what you can and can't do. Years ago, before there was a whole lot of structure around this, I was with a company. We got sued because collector started, now they call it cyber stalking. But he was just following a customer around. And that became a lawsuit. And that stuff happens all the time. I had a dealer recently that had a big battle within the company because they had different locations, and one location was checking out the driver cars. Where are they going? Because they thought the other store was going for beers in the middle of the afternoon. This stuff happens. Have policies about it. Anticipate this stuff. Don't call your devices theft deterrent devices. Regulators hate that. They think it's dishonest. These are GPS devices. They have a purpose. Just say what the purpose is.
Do customers have to sign some sort of waiver?
In most states, yes, and it is certainly a best practice. And just about any GPS company out there is going to have a form that their lawyers have done that's a really complete disclosure about everything that you're going to do with that information, how you're going to use it. I don't know that I've seen the Frazier one recently, so I can't say, but if you want to get my email address and send it to me, I'll be glad to take a look at it. Okay? For those of you in military areas, and really anybody with any military customers, know what the rules are about military customers. Know what the Service Members Relief Act is. Know when you have to reduce it down to 6%. Know your repossession rights, which basically aren't any. Know what you could do with spouses and other people driving the car. Never repossess a car without checking the Department of Defense database and making sure somebody's not in the military. Because the way the CFPB has positioned its consent decrees, it's about a $10,000 fine per violation or more. So those are really dangerous. Bankruptcy accounts too. Some of you are going to be in areas where bankruptcy is a hot button. Other ones are going to be in areas where you rarely see bankruptcy. But whenever somebody throws out the bankruptcy word, know what you have to do, know what you can't do. I tell everybody, give your collectors a bankruptcy talk-off. By talk-off, I mean give them a couple of lines. If somebody says, I have filed bankruptcy, here's what you do next. If they threaten it, but they haven't done it yet, that's a different talk-off. But have a strategy in place for making sure that you don't trample the automatic stay. Because once they're in bankruptcy, even if you've repossessed the car already, if they jump in bankruptcy before you've sold it, you can't sell it. Understand what you can and can't do. A lot of bankruptcy law, there's one law, but there's about 9,000 different local interpretations of that law. Know what flies in your area, what the judges will allow and what they don't like to see. Understanding and using arbitration clauses. I told you in the beginning of this presentation, I love arbitration clauses. They're very important, but read yours. Don't think that, my DMS gave it to me 5 years ago, it must be great. Understand what they say, because some of them have payment sharing provisions where you've got to cover the cost of the arbitration. You've got to put money up front. Know what your rights are, know what the customer's rights are. But arbitration is one of the safest things you could do. Yeah? They did try to get rid of arbitration. It failed, and then Cordray left, and Mulvaney came in, and they've basically lost that battle for now. But the Maxine Waters and the Financial Services Committee in the House of Representatives thinks that arbitration is so evil, and they continue to attack arbitration. I don't think they're going to take a run at changing things in Congress before the next election, but after the next election, if it's a Democrat-controlled House and Senate, I think arbitration is going away. So enjoy it while you can. What the CFPB was told was, you guys can't go back and try to stick in the arbitration prohibition again. But Congress can. Congress has the power to say we're either going to amend the Federal Arbitration Act or we're not. It's a really important tool, so keep an eye on that.
Do the states have the right to eliminate arbitration?
They have some rights, but they're preempted by the federal law. So the Federal Arbitration Act controls. But depending on what state you're in, that there can be state nuances to it. For instance, judges in California look for any way to throw out an arbitration clause. You have other parts of the country that are much more friendlier to arbitration clauses.
You have an attorney that might bring up arbitration clause on our finance contract, and they try to use a mediator or mediation. Is mediation more favorable for either party, or should it be avoided and forcing those to arbitration?
Mediation and arbitration are two very different things. Mediation is more of a voluntary process. Arbitration is a very formal process through American Arbitration Association or one of the other panels. They're the administrators of it. They have laws. It's like being in a different kind of court. It's a lot more structured. I think it's a really good idea, and this is a good technique you guys need to remember. If you have a customer complaint and you guys aren't able to resolve it with the customer, maybe you throw out the idea of mediation. Just about any big city is going to have a free mediation service. I've used it before. I've served as a mediator before, too. I think it's a great process to kind of get to the bottom of the issue and move on. So consider it. You don't have to go to arbitration, but if you do, and you do a signed agreement among both parties, the courts in the jurisdiction will usually enforce it because it was signed by the two parties and a mediator. Finally, we're almost out of time. I can't stress enough having a training strategy. It doesn't have to be fancy, but have some sort of training strategy. I like any training where there's a back and forth dialogue between the trainer and the people being trained. I'm not so crazy about all those online things out there where it plays for 10 minutes and then you check a box that, yeah, I went through training. I like the ability to ask and answer questions. I think that's really important in training. If you want some ideas about how to develop one, just give me a call. We'll be glad to talk to you about it. No obligation or anything. I think it's really important to teach people how to do that. That's why we do it. So thank you for hanging around until the bitter end. I'm going to be here to answer any questions. Feel free to stop me. So thanks very much, everybody.